Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is part of our At the Round Table playlist, dedicated to a variety of discussions ranging from specific issues to more general topics. In this series, we create a space for exploration and collaborative insights on matters that impact our criminal justice system. Whether we are focusing on a single pressing issue, such as joint enterprise, for example, or taking a broader look at trends and ideas, as we will do today, for example, this playlist is designed to foster meaningful dialogue and expand our understanding of the criminal justice system. In today's video, we will delve in particular into data extracted from a library recently launched by the Criminal Cases Review Commission to investigate whether we can identify recurring patterns in wrongful convictions and examine if the referral data reflects the shortcomings and concerns raised by academics and researchers. We will also explore whether these data suggest that the CCRC may be failing short in fulfilling its role, at least as far as certain referral categories are concerned. So grab a drink and be sure to have your thinking cap and notebook ready to join the discussion in the comments section below. On the 9th of September 2024, the Criminal Cases Review Commission, or CCRC, launched a public library of all cases it has so far referred to the courts since its inception in 1997. The announcement states that the case library aims to help potential applicants understand the reasons why a conviction or a sentence might be granted a fresh appeal. It says it will also be a useful point of reference for journalists, researchers, legal professionals, and those interested in miscarriages of justice. In that regard, I will add this video to our tips and lessons playlist as well, as it might be helpful for those of you preparing a CCRC application by offering insight into previously referred cases and the arguments used. While the summaries are rather brief, they do provide case names that you can research and reference for further information. So let's take a look at the library. First, we note that you can filter it according to the type of offences, for example, arson, criminal damage, fraud, the type of referral, for example, abuse of process, change of law, human rights, and to the type of process, for example, convictions, sentences, cost orders, or simply, if you know the name of the case you are looking for, you can type either the first name or the surname or both in the top search bar. The first piece of data we observe is the total number of referrals, which stands at 848. Of these, 743 are related to convictions. Out of those, 500 convictions have been quashed and 204 upheld. We note that by adding these numbers, we are left with 39 convictions unaccounted for. So let's try to understand the reason beyond this. First, referring to the news release from the 9th of September, the article states that the CCRC has so far referred almost 850 cases back to the courts. Over 820 of those cases have been heard, with the appeal successful in more than 2/3 of them. Given that we know there are 848 total referrals and 820 have been heard, this leaves a gap of 28 cases which are still pending. Assuming that all 28 are convictions, still this does not fully explain the discrepancy, as it leaves a further 11 uncategorized convictions. Looking elsewhere within the CCRC website, we also note that of the post office cases, 77 were referred, but only 69 were overturned. We are not sure whether the remaining 8 were upheld or were pending or not decided. And if they were not decided and pending, of course they will no longer require determination, given, as we know, the Post Office Horizon System Offences Act 2024, which effectively quashed those convictions. Nevertheless, if we are to add these 8 cases, we are still short of 3 convictions which remain unaccounted for. Could this suggest that the library's data may not be fully reliable? Or is there another explanation? We have not reached out to the CCRC for clarification, so we will avoid the speculation for now. However, if you have a concrete explanation for this discrepancy, no speculation please, do share it with us in the comments below. However, setting aside the discrepancy, our first finding is that according to the data, 58.9% of referred convictions have resulted in quashed convictions. Do you think this is an acceptable rate? This is not, by the way, a rhetorical question, but actually a genuine question eliciting your thoughts. So do let us know in the comments below. As far as referral categories are concerned, we can see from the drop-down menu that the CCRC identifies 22 distinct categories. To gather data, we first identified the total number of decisions within each category by selecting the appropriate category and pressing the search button. The total number of decisions appears in the upper right corner. We then compiled the results for each category into a chart to visually illustrate our findings, highlighting the categories that are most frequently referred. As you can see from our charts, the top 5 categories are abusive process, credibility and unreliable witnesses, new expert evidence, non-disclosure, and new medical psychiatric evidence. Based on the cases we have reviewed so far in our trial, these results are unsurprising. For example, we examined the post office cases which fall under the abusive process category. Given that the post office scandal is one of the most widespread miscarriages of justice to date, it's not surprised that this category ranks highest. However, since many of these cases are linked to the post office scandal, we question whether this might skew focus away from more pressing issues, such as witness reliability or expert evidence. Additionally, we examined Mr. Markinson's case. This case, in fact, is relevant under more than one category, as it touches issues of credibility and unreliable witnesses, as well as new forensic evidence and non-disclosure issues. So nothing surprising there too. However, of particular note is that, bizarrely, we were unable to find the case of Mr. Markinson in the library database. We searched by both name and surname in the top search bar, and we also searched under several categories such as unreliable witnesses, non-disclosure, new forensic evidence, but found no results. Is this another indicator that the library is not entirely reliable? Again, we refrain from speculating. An additional point of note refers to expert evidence. However, before going into any details, if you are finding this video interesting so far, please click the like button below and subscribe to our channel to help us with our mission to humanize wrongful convictions. So going back into our CCRC data analysis, we found intriguing that medical, psychiatric, forensic and pathology evidence are listed separately from expert evidence. In our view, this should all be grouped under the category of new expert evidence. If combined, it becomes clear that this is by far the most concerning category, as you can see from our chart. For those of you who have been following the Letby case and the latest developments, you can understand why this is a particularly troubling category. As we know, the case involved the deaths, injuries of neonates, where the cause of death or injury was medically complicated. This meant that medical expert evidence as well as pathology evidence was crucial in determining whether the deaths and collapses were the result of natural causes, medical complications, or deliberate actions. In complex medical cases such as these, experts often deal with uncertainties and grey areas. Even well-qualified experts can disagree on interpretations of medical data, and these nuances are not always effectively communicated to juries. There is a risk that juries might treat expert testimony as conclusive or unquestionable, rather than as one part of a broader puzzle. This raises the issue of how well evidence is presented and cross-examined to prevent over-reliance on potentially inconclusive opinions. Particularly as in the Letby's case, there were no defense expert witnesses. In addition, there is the challenge for non-medical professionals such as lawyers, judges and jurors in interpreting high technical expert evidence. Judges and juries may struggle to evaluate the credibility of expert testimony, especially in high technical fields like neonatology or pathology. This raises the question of whether additional safeguards, explanatory resources are needed to help the courts make informed decisions. To this, we must add also the potential for bias in the selection of expert witnesses. In fact, in general, there is a tendency to choose experts who align with a certain theory or who are willing to present the prosecution or the defense case in a favorable light. Selection bias can occur when experts are chosen based on their agreement with the preferred narrative rather than on their ability to provide an objective, balanced view of the evidence. These can skew the overall presentation of expert evidence and lead to imbalanced or misleading outcomes, with jurors possibly influenced more by the presentation of the expert than the substantive quality of the evidence. Experts are often seen as authoritative figures, but medical science, particularly in areas like neonatology, is frequently evolving and uncertain. Overconfidence in certain conclusions can obscure the reality that medical evidence is rarely definitive. In cases where the science is not settled, courts must be careful not to treat expert opinions as absolute facts. There is a need for courts to remain vigilant about potential overstatements made by experts. We are in no doubt that tighter guidelines on the admissibility of expert evidence is needed. Ensure that experts' qualifications and the reliability of their methods are rigorously vetted before they testify. Improving training for lawyers and judges in dealing with expert evidence to ensure they can properly challenge, question, and interpret the information being presented. Clarification for juries on how to weigh expert evidence so they are less likely to default to believing experts simply on their sounding authoritative. Let us know what you think in your comments below. But back to our data, what else can we spot from the 22 categories? We note that joint enterprise has been a cause for referral in only 19 cases. Given the amount of criticism directed at this legal doctrine, the number of cases referred appears to us simply too modest. As highlighted in our video, Caught in the Net Entangling Joint Enterprise, the joint enterprise doctrine has been highly controversial in the UK, as critics argue that this doctrine disproportionately impacts young people and those from marginalised community, often leading to harsh sentences for individuals who had minimal involvement. They also argue that relies on problematic assumptions about intention and foresight, making it easy for juries to convict secondary participants. And they argue that it has led to wrongful convictions, as individuals may be held responsible for the actions of others without concrete evidence of their direct involvement in the crime. Could the fact that the Criminal Cases Review Commission has referred very few joint enterprise cases since its inception, especially considering legal developments like the Joggi case, which clarified and narrowed the scope of joint enterprise convictions, be seen as a failure of the CCRC? This is particularly concerning given the significant criticism and attention that joint enterprise has drawn in both legal and public discourse. Has the CCRC been too cautious and reluctant to challenge these cases? Has the CCRC fully embraced the legal shift in the Joggi case? Is the CCRC fulfilling its role as a safeguard for justice, particularly in areas where legal doctrines are complex, highly criticized, and may disproportionately impact certain communities? Has the CCRC ability to refer joint enterprise cases been constrained by the real possibility test, to which we referred in our video Criminal Cases Review Commission Last Gasp of Survival? Has the CCRC adequately responded to public and legal criticism of joint enterprise? And should it place a greater focus on reviewing these cases? I look forward to your views in the comments below. I hope this video has sparked some meaningful discussions and debates. If you found it interesting, please like the video and subscribe to our channel to support our mission of highlighting the shortcomings in the criminal justice system. As Julian Assange said, none of the resolutions, reports, films, articles, events, fundraisers, protests and letters over the past 14 years should have been necessary, but all of them were necessary, because without them I never would have seen the light of day. This unprecedented global effort was needed because of the legal protection that did exist. Many existed only on paper and were not effective in any remotely reasonable time. It's crucial that we continue to question the system and advocate for change where protections are inadequate. When the system goes unchallenged, it breeds stagnation, inequality, and injustice. Join us again as we sit and rise in this unique trial.